Shri Pandey therefore submits that the state government exercises control over the chairperson and its members and hence they are under the state government stop. He also submits that the state human rights chairperson being under the direct control of the state government in respect of his appointment and terms and conditions including salaries and allowances amounts to an employment under the state government stop. He therefore submits that this clearly attracts the ineligibility clause of the 1985 Act referred to herein above and consequently this legal defect cannot sustain the impugned appointment of the chairperson stop. Shri Pandey has further urged that it is the intention of the legislature and such similar provisions contained in other laws that should be taken into consideration to construe the aforesaid provision attracting the ineligibility as pointed out above stop. Through another supplementary affidavit, he has invited the attention of the court to Article 319 of the Constitution of India, which also entails such ineligibility for the chairman of the Union Public Service Commission, the provisions of the Telecom Regulatory Authority of India Act 2014 in respect of the chairperson of the said authority and the provisions of section 5 of the Uttar Pradesh Lokayukta and Up Lokayuktas Act 1975 to contend that there are such similar disqualifications that have been prescribed and consequently the same principle should be applied to construe that the appointment of a chairperson of the State Human Rights Commission should be treated to be an employment under the state government. Stop stanza. Shri Vijay Bahadur Singh, learned Advocate General, on the other hand, has urged that the constitution of the Commission under Section 21 of the 1993 Act and the appointment under Section 22 would leave no room for doubt that it is the state government which constitutes the Commission and the consequential act of appointment follows after a recommendation is made by the committee as defined under subsection within bracket 1 of section 22 of the act stop. His Excellency the Governor then under his warrant and seal issues the letter of appointment stop. This is not an employment as understood in service jurisprudence as that of a master and a servant or even in terms of employer and employee relationship stop. He contends that once a chairperson is installed in office, his removal is only by His Excellency the President of India after an inquiry through the Supreme Court. Stop. The state government therefore does not exercise such control in relation to the removal of a chairperson who can otherwise himself resign from his office. Stop. Salaries and allowances which are payable and the terms and conditions of service are in order to facilitate the functioning of the chairperson as the chairman of the State Human Rights Commission. Stop. The Human Rights Commission is a body to conduct and supervise all inquiries relating to human rights violations which is not subject to any control or supervision by the state government, and he has substantiated his arguments by contending that this appointment of a chairperson is not under the state government but is under the 1993 Act. Stop stanza. The basic facts which are not in dispute before this court is that the appellant came to be selected for the post of stenotypist in Hindi in PWD following a regular process of selection in pursuance of an advertisement stop. Under the terms of the advertisement, candidates were required to possess a minimum typing speed of 80 words per minute in taking Hindi shorthand and 25 words per minute in Hindi typing. Stop. The appellant qualified in the selection process and was duly appointed. Stop. Though the appellant was placed in terms of the office memorandum on a temporary basis, it is not in dispute that the appointment was against a substantive vacancy after a regular process of selection. Stop. The complainant sought to question the process of selection by leveling allegations of irregularities against the appointing authority to the Chief Minister. Stop. Following this, an inquiry was held by the Additional Commissioner in which the complainant was called upon to participate. Stop. Significantly, the appellant whose appointment was being questioned was not associated with the inquiry. Stop. Based on the report of the Additional Commissioner, a conclusion was drawn that the appointment was improper, and accordingly, on 27 July 1999, the appointment was cancelled. Stop stanza. There is merit in the submission of the appellant that this has not been preceded by a recourse to the principles of natural justice. Stop. In the facts of the present case, as we shall indicate hereafter, the method in which the typing speed was to be calculated has itself been a bone of contention. Stop. Particularly in a situation where the complainant was heard, but it was appropriate and proper that the appellant should have been heard, where the consequence of the report of the Additional Commissioner was to visit the appellant with an order of termination. Stop. Absent compliance with the basic principles of natural justice, there has been a patent unfairness in the process which has been adopted by the authorities. Stop stanza. The disciplinary inquiry, which was concluded against the appointing authority, resulted in an inquiry report dated 18 November 1999 of the chief engineer, which exonerated the appointing authority. Stop. In fact, we may note that the evaluator who was examined during the course of the disciplinary inquiry explained the basis on which the typing speed of the appellant had been computed. Stop. The appellant has relied upon this aspect of the disciplinary inquiry. Stop. The evaluator sought to explain the evaluation of the answer sheet by stating that the typing speed of the appellant has been computed as 31 words per minute, 156 correct words divided by 5 minutes. Stop. We are indicating this aspect because, particularly in a situation like this where there is no allegation of fraud against the selected candidates, it is but necessary and proper that a termination of the services post appointment should have been preceded by compliance with at least the basic norms of fairness. Stop. The inquiry was held completely behind the back of the appellant and his services were terminated in consequence. Stop stanza. The learned single judge has dismissed the writ petition on 2 February 2016, holding that the charge of the appellant having consumed alcohol while on duty stood duly proved in the inquiry proceedings. Stop. The learned single judge found no merit in the submissions urged before him that the charge of intoxication could not have been established or proved unless a blood and urine examination had been performed. Stop. Before us, the learned counsel for the appellant has reiterated the above submission and has contended that the medical evidence which was gathered in the course of the inquiry was clearly inconclusive and could not have been formed the basis for holding the appellant guilty and his consequential termination. Stop. Stanza. The incident itself is stated to have occurred on 23 July 2009 while the appellant was on security duty near the premises of a bank. Stop.